Yes, Carty.
My Lord, if I may come back to the miscellaneous factual questions that we've now had a chance to find the answers to. So, in roughly the order in which I think they were asked, we've had a look again at the CAVIA clause 4.5. That was the clause in the CAVIA agreement relating to the prohibition on ISL to charge any further money.
Yes.
We think that that must be a prohibition on ISL to charge any further fees in relation to the 4.4 matters, so the device matters, either to policyholders, or sorry, to both policyholders and to CAVIA. That's how we interpret it. The second point, yes, the diagram in the skeleton argument wasn't quite right. The net premium should have been, I think it was 900 rather than 1,000, and so we point to the worked example, PDF supplementary bundle, PDF page 254, which shows the amounts being split out. So that's one correction just to our skeleton argument diagram. So net premium of 900 as opposed to 1,000. Your Lordship asked about the process if a customer already has a box. So this will occur in two different ways. First of all, on renewal. But on renewal, there isn't the same customer journey that the customer goes through. The customer is simply sent the renewal letter, and his premium will be lower by £150 than it would otherwise have been if he was a new customer joining from the outset. In the event that there's a customer who...
There's a renewal letter that quotes him a renewal premium, is there?
Yes, exactly, yes. And the renewal premium will not include 150 because that customer already has a box. In the far rarer case where someone isn't renewing, but they happen to have already had a box because they were a previous customer, and then 2 years pass when they're not a customer, and then year 3 they come back, my instructions are that that was simply a rare event, and so it would simply be something that ended up being resolved by dialogue between the relevant parties. But the result is that if Ingenie could revive the box and get it working again, that customer wouldn't be charged an additional premium. But that was something that didn't happen that often. So a standard renewal would happen frequently, but that isn't done through the website. That's simply a renewal letter is sent with a lower premium. In the off chance that it was a customer who had insured their car with someone else for a couple of years in between, but still
I understand what
had
you're
a box,
saying, but I'm not sure Ingenie would know whether they were going to be able to renew the box until after the policy had incepted and the premium had been quoted and paid.
So the assumption is, and again, this happened rarely, so there wasn't necessarily a practice, but the assumption is that customer might in fact have phoned rather than simply gone onto the website. So the dialogue would presumably be, if it's a customer that knows that he already has a box in his car, he might simply leave the phone and it's resolved that way. So, but there aren't any findings. This would have been a rare event and not something that happened routinely. But in that case, if the box could be revived, then the customer wouldn't have been charged. This isn't a customer that would have gone through the website customer journey, but there's no tick box to say tick here if you happen to have been a customer many years ago. If a customer misses an appointment, so those fees that we were looking at in the TOBA, then ARL would charge a fee, the missed appointment fee passed back to ISL, and this is referred to indirectly Upper Tribunal paragraph 59 brackets 11 in the Upper Tribunal summary of the first tier's findings. So ARL would charge the fee to the customer, ARL would pass that money back to Ingenie, e.g. for a missed appointment. Your Lordship asked the question, what would happen with the policy booklet once the customer had entered into the policy? So we know it's there for the customer to click into before the customer takes out the policy. What would happen after? And the reference is First Tier Decision, paragraph 31. So that's Core Bundle 11, page 159. With the welcome letter, ISL also sent the policyholder the Ingenie car insurance policy wording, which Mr. Proctor-Wilson referred to as the policy booklet. So the policy booklet was sent with the welcome letter. It may be. I don't have the transcript available to me now. It may be that was something that came up in cross-examination. I don't think it matters to the supply analysis. It hasn't been something that I've been able to check, but that was the first tier's finding.
Thank you.
And I think those were all the questions that we had been asked. So before the short adjournment, I've just shown the tribunal just to nail down the contractual interpretation argument. We looked at Chitty, we looked briefly at open work, we also looked at Charnock and Liverpool. And we say that it's important to recognise that here we're not starting with a blank piece of paper on the question of whether the policyholder has done something in return. We're told that Section 1 is a contract, and that is only correct if the policyholder has done something in return. And we take from open work, for example, that the court will strive to give meaning to the terms used, in particular if there's an intention to contract, and we say that that, properly construed, is a clear intention to contract. Now, pausing there, both the First Tier and the Upper Tribunal accepted that entering into a contract with a third party could be consideration for that. So they didn't say, in principle, it's the wrong type of consideration. And for your note, that's First Tier 89 and 91. The first part of 91, the second part of 91 is in essence why the First Tier found against us. And if I could ask you just to turn that up briefly, please. So that's First Tier decision, core bundle, tab 11. Page 169. So 89 set out our arguments. 91 is the tribunal accepting that entering into a contract could be sufficient consideration. You'll then see over the page, at the bottom of paragraph 91, the difficulty that Mr. Parker for ISL faced in this case is that the policy booklet does not contain any term under which the policyholder agreed to do anything. So again, this is back to the lack of anything written on the page, which we say at a level of contractual interpretation is just simply the wrong approach, construing the rights and obligations. Then when we look at what the Upper Tribunal said, the Upper Tribunal agreed with the proposition that entry into a contract could be sufficient consideration. That's Upper Tribunal decision, page 102 of the bundle. Bless you. Paragraph 88. So we didn't lose because of some higher principle of that law. We lost apparently according to the tribunals because of something in our facts, which they then in due course attribute, certainly the Upper Tribunal does explicitly, to this notion of direct link. One of the problems that I would say with the tribunal's approach is that it's incomplete. If we start from the premise that there is a contract, that means that the policyholder, as a matter of rights and obligations, has given something of value in return. If it isn't possible to identify what else the policyholder may have given in return, we say that counts for something, that we must be right about our candidate for consideration. Because the tribunal can't have it both ways. The tribunal can't say, well, we acknowledge that there is a contract, a proper enforceable contract. We don't think that the tribunal gave what you... we don't think that the policyholder gave what you say he gave, and we don't need to deal with anything else. Because we would say that that's an incomplete answer. The way I put it is this: if there's no other candidate for what did the policyholder then give in return, that is at least support for our argument being right, that what was given in return was entry into an insurance contract. Otherwise, you just have analysis that simply doesn't link up. And bearing in mind you have to start from the English law position in terms of interpretation, we can't say, it's not for the Upper Tribunal and First Tier to say, oh, well, it doesn't matter whether or not there's an English law contract because the language is legal relationship. It's just simply not analytically complete to say that. And we are entitled to know why it is we won or lost, but that is an inconsistent decision. That's inconsistent analysis. And we also say that analytically, I've shown your lordship secret hotels too, one can't move on to the question of direct link until, as a matter of contractual interpretation, one has nailed down what the rights and obligations are. And neither tribunal ever does this. They merge the direct link analysis into looking at the terms of the contract. And that's a big reason why they went wrong in approach. So I appreciate my skeleton talked about English law consideration. I don't want to use that labelling because maybe that's not helpful. But at a fundamental level, as a matter of English law, we say we have identified something that the policyholders have done in return. Now that we have identified that, we move on to the direct link question and the direct link cases. And what I will show you is that that doing in return, that entry into the policy, is sufficient for there to be a direct link in that, because actually a direct link is a very loose test. All it means is in return. Your Lordship, Lord Justice Nugee asked before the short adjournment about unilateral contracts. And when we go to look at the cases, you'll see in particular Empire Stores concerns a unilateral contract. That was the case where if you introduce a friend, you'll get a toaster, and there's obviously no obligation on anyone to introduce anyone to Empire Stores. So that's a clear case of unilateral contract. My Lord, Lord Justice Popplewell also pointed, I think, to the extract about mutuality in our skeleton argument from the Spartax case. And we'll see that taken in context, first of all, the CJU wasn't seeking to overturn Empire Stores. Empire Stores is long-standing, well-established principle. But secondly, the context in which that quote arose was the premise of paying to visit a spa, and no one's forcing anyone to visit a spa. So it's not only bilateral agreements entered into on day one where there are obligations on both parties that can amount to consideration. But we'll see that in the cases. It is true that a lot of the direct link cases arise in that circumstance, but that's not the only scenario. And Empire Stores is the clearest example of that.
And was Thorn another unilateral contract case?
Thorn is another unilateral contract case. It is an old case of the VAT Tribunal, which, if I don't say that, my learned friend will. But nonetheless, its reasoning is coherent, and we say right, and so none the worse for it. So if I can then move on to, this is the third subsection. So we've done what role the contract plays, we've done what are the rights and obligations. Now the punchline, there is a direct link. Subsection 3 of this argument. If I can first set the scene for where this question arises in the VAT analysis, and I can do that by asking you please to look at Upper Tribunal decision paragraph 56. So that's core 7, page 95 of the bundle. Paragraph 56. We'll see that for there to be a supply for consideration, there need to be the following elements: a supply of goods or services. Critically, we've won on that first case. There is a supply of services, so the Upper Tribunal has found, and the revenue isn't taking a point on that, from ISL to the policyholders. There must be a legal relationship. Again, no one seems to be disputing that anymore. There must be reciprocal performance pursuant to that relationship. And then where the consideration is services, there must be a direct link between the supply by the supplier and the provision of services by the recipient. Now, the way we'll see from the cases talk about this is reciprocal performance as part of direct link. And so how I intend to approach this is simply by addressing you on direct link, because if we're home on direct link, necessarily you've agreed that there's reciprocity. I don't think it's possible to have one without the other, so I wouldn't necessarily say they're two discrete tests, and even the Upper Tribunal acknowledges that. And then 5, the value of the services supplied must be capable of being expressed in monetary terms. I'll pick that up when we touch on Empire Stores. So really the focus of my submission is on 4. If you're with me on 4, necessarily I'll have satisfied you about 3 as well. And it's paragraph 83 of the Upper Tribunal's decision, where the Upper Tribunal noted that the Court of Justice refers to recipient performance as one element of a direct link. So, turning to the relevant authorities on direct link, I'm going to go through the cases chronologically, save that I want to deal with South African Tourist Board at the end. And the reason for that is the Upper Tribunal in its decision took one paragraph in that case completely out of context, emphasised by emboldening certain words that suggested that direct link was some sort of high hurdle. And when I've shown you the rest of the authorities, you'll understand why actually the Upper Tribunal misunderstood and misapplied that case to our facts. Just to be clear, South African Tourist Board, a decision of the Upper Tribunal, establishes no new principle. We agree with the principles, we agree with the decision, we do not in any way need to challenge the decision. What we challenge is what the Upper Tribunal took from it. And I would just add, South African Tourist Board was a case the Upper Tribunal found of its own accord. It wasn't cited by either party. So it is unfortunate that the Upper Tribunal plucked one paragraph out of it and seemed to make a lot of it by emphasising part of it wrongly. The cases that I'm about to go through can be grouped into 2 loose categories. The relevance of me explaining this first will become very apparent when we look at South African Tourist Board. But very loosely, the first category is establishing whether or not goods or services were provided gratuitously. So was it for free or did you pay consideration? The second category is slightly different, and that is whether or not the putative customer received something specific in return that amounted to a supply to him. The distinction will become clearer when we look at the cases, but I just want to say up front, we are the first category of case. It is established that ISL made supplies to policyholders of specific things. The only question is gratuitous, yes or no. We are not the second category of case. Cases such as Appellant and indeed South African Tourist Board are the second category of case, where the finding is there's no supply for consideration, ultimately because what was done in return for money was not specific enough to amount to a supply to the customer from the service provider. So then starting off with the authorities, if I could ask you please to go to the authorities bundle, and this is tab 11, page 249, it's the Dutch potato case. So this is the earliest decision judgment of the CJEU, setting out the relevant principles on consideration. Broadly, the case concerned a cooperative that provided potato storage facilities for its members. In the years in question, it did not charge a fee for those storage facilities, but the tax inspector thought that the relevant members had provided consideration. The reason they gave was, well, because the cooperative didn't charge a fee, your shares that you, the members, have necessarily fell because the cooperative wasn't making any money from you. Therefore, that's consideration for a supply. And the revenue inspector said, well, we estimate that the output tax that you should charge should be half of what you'd usually charge in relation to storage fees. And the CJEU said, no, that's not the relevant direct link. If I could ask you please to go briefly to 256, page 256, paragraphs 2 to 3 of the judgment. That sets out briefly the facts. and 3 in particular shows you what I've just summarised. There nevertheless was some sort of charge because of the fall in the value of the shares that the members owned. If I could ask you please to go forward to then of the reasoning. Paragraph 9 on page 257 simply tells us that for consideration is a VAT notion. It doesn't turn on whether or not something's consideration as a matter of domestic law of the member states. And the core principles are set out at 10 through to 14. And if I could just ask your lordships to read that briefly, please.
Sure.
10 through to 14. And you'll see at 10 that the old provision used to say the consideration was understood as everything received in return for the provision of services. That express definition doesn't appear anymore, but the understanding is still, the common understanding of what consideration is still the same as that. And it's easy to see in such a case as that why this notion of direct link came about. Because it's admitted that there's nothing actually required of the growers, and some indirect reduction in value of the member shares is not enough for there to be consideration. Moving on then to Appellant Development Council, which is behind Authorities tab 13. If I could ask your lordships just briefly to read the head note, which is on page 278, and you'll see that this is a case where the payer received nothing specific in return.
Tab 13. Did you think you may have said 14? Is it?
Oh, I'm sorry. Have I
may have misheard you. Anyway,
13.
13. Yep.
Yes.
Yep.
And so you'll have seen in this case, we can all see that the putative customer has paid, but the reason that there was no supply for consideration is because any benefits accrued to the industry as a whole, the individual members were not getting a supply in return. So not our case, albeit we do learn about direct link and the principles. And the way that the Advocate General expressed the position, if I could ask you please to go to page 291 of the Authorities bundle. So bottom of page 291, this is in the Advocate General's opinion. The need for a direct link is also to be seen. And then over the page, his reasoning between A and B. It seems to me here that the payment here is only indirectly for the benefit of anything received by a particular grower. And then there's a discussion about how it might be coincidental that the bigger growers who pay more indirectly receive more benefit. And if I could ask you just also to look further down the page between D and F, the first paragraph starting in this case, And then the second paragraph starting, it does not seem to me. And you'll see there the language of bargain just by little f in what the Advocate General says. Then looking at the court, please. So PDF page 294. If I could ask your lordships, please, just to read 11 through to 16. And so the thrust of the decision here was there's no relationship between the benefits and the payment. Payments were always recoverable, even if no benefit was received. So again, as I said, this isn't our type of case. This is well, we all know you've made a payment, customer, but did you actually get a supply? Answer, no, for these reasons, because there's no direct link. But we are in a different position. Our starting point is we have made a supply. ISL has made a supply. Not to say that the principles don't equally apply, it's just pointing out the difference, which will become very clear, and the importance of this difference when we look at South African tourist law in particular. So the next case then is Naturally Yours Cosmetics, which is one tab back in tab 12. Apologies, they were put in the bundle in the slightly wrong order. This is a case which demonstrates the breadth of acceptable consideration that a customer can give. It also makes it clear that consideration from a customer can include non-monetary consideration. And it provides guidance on how non-monetary consideration can be valued. The reason why I keep saying Empire Stores is in fact the case on valuation rather than Naturally Yours is because Naturally Yours was a circumstance where, as we'll see from the head note in due course, the supplier actually sold the goods in question at a market value. And for certain reasons, certain individuals were offered were offered the goods at a reduced price, if and only if they used the goods in a certain situation. And that was the relevant service. When it came to valuing the consideration, as we'll see, the court said, well, we know that you Naturally Yours would sell them to everyone else for, I think it was £10.40. Therefore, the value of the service element is the difference between the price that these individuals were required to pay, which was £1.50, and so overall output tax on the £10.40. We're not this case because we don't sell devices and device services in the open market. We'll see why, therefore, when we get to Empire Stores, why we're focusing on the cost, because we don't have that same starting point as a comparator. If I could invite your lordships just to read the head note first. And you'll see that the taxpayer, the supplier, was trying to argue that it should only be output tax on the £1.50 because that was the monetary consideration. Answer, no, because the customer also provided something else of value in return, being these services. If I could then ask your lordships to turn to page 270 and read 30 to 34 of the Advocate General. So page 270 in the bundle, 30 to 34 of the Advocate General, please. And the read across here, which you'll see also arising in Thorn, is ISL isn't in the business of giving out free gifts to policyholders. It has an interest in the policyholder entering into the contract of insurance because that is how it will be paid. And it's for that reason alone that ISL doesn't charge the policyholders a separate fee. So the transaction is enter into the insurance policy and we'll supply you with the items mentioned in section 1. No entry into the contract, no device, no items in section 1 of the policy. And in Naturally Yours, the customer consideration was £1.50 up front, plus then the undertaking to host a party. And if the party wasn't held, then either the goods had to be returned or full price paid. Moving on then to the judgment, please. Page 275 of the bundle. 3 to 5 summarises the facts that you'll have already seen. And if I could invite the court, please, then to read paragraphs 11 through to 18 of the judgment, which starts on 276. So 11 through to 18, please.
We'll read those.
And so just on the point of being able to apply a value to consideration, the beauty consultants here weren't in the business of offering their services for pounds in the open market. So it wasn't the case that there was a starting point for, well, this is how much we offer our services for. The question is then, if the service of procuring a hostess to organise a party is to be consideration, how do you attribute a value? That has to be a subjective value. What is the supplier, here Naturally Yours, willing to pay in return for that service? And Naturally Yours was providing to the beauty consultants cream that it would have sold for £10.40 in return for money of £1.50 plus the service. So what's the value of the service? What's the value of the service to the company? It's the difference. That's the price that the supplier, Naturally Yours, put on the service that it was receiving in And it's able to do that because it has goods that it offers on the open market for sale. So there's that benchmark.
It's expressed as being the value which both parties to the contract put on it, not just yours as the recipient of the non-monetary consideration.
And it makes sense both ways round in this example, because the beauty consultant will also know that they have received something that they would otherwise have had to pay 1040 for.
Yes.
When we come on to Empire Stores, of course, the customer in that case has no idea what a toaster would retail for or how much Empire Stores bought it in for. But you'll nevertheless see that the cost to Empire Stores was then, in the absence of these toasters being sold on retail, was then that which was used for the subjective monetary value. Moving on then to Tolsma. Tolsma is the case about a busker who collected money from passers-by. Someone wanted to subject him to VAT, and answer, obviously not. Tolsma is Authorities tab 14. And you'll see it's as simple as I've just expressed it in the head note. If I could ask you please to move on to page 299 of the bundle, so 14 to 22 of the Advocate General. At 14, the Advocate General summarises the principles that we know well. At 17, the Advocate General makes the point that there's no direct link, the receipts are just voluntary decisions by passers-by. Moreover, at 18, the service itself is not defined. So this is a case where both any money was gratuitous and also there wasn't a sufficiently identifiable supply anyway. 18, Mr. Tolsma plays music voluntarily. 19, it's not possible to establish the necessary relationship between the benefits and the fact of the payment and its amount. And you can see from 19 through to 22 all the reasons why you wouldn't expect a busker collecting voluntary donations to be providing us any sort of service for consideration. Thorn is the next case in the sequence, and this is at page tab 16 in the bundle, starting off page 315. And if I can ask your lordships,
and Tolsma, you haven't taken us to the passages in the judgment of the court.
Oh, I'm so sorry.
But they do essentially adopt that reason.
I'm so sorry. I had actually meant to. I just skipped over it in my notes. It's in particular paragraphs 13 to 19 in the judgment, page 302.
Yeah.
I'm sorry, and as you are quite right, the court simply adopts the reasoning.
I mean, it does seem rather extraordinary that the authorities should have even thought it worthwhile trying to take a case like that. I mean, you would think if anyway, in any event, the busker's income would be well below any VAT or threshold.
Yes, I think some other countries have very low VAT thresholds, which is
maybe they must
why.
But, well, perhaps they have very, very efficient buskers.
But in 1988, no one knew much about that, so that's the only reason why they presumably thought it worth to have an Advocate General giving his opinion as well. So then moving on then to Thorn, which is tab 16 in the bundle. And the crux of what is going on in Thorn is summarised at paragraph 5, which is 316. And it's essentially the sort of offer, and I paraphrase, but sign up to this mobile phone contract, we'll give you a free phone. That's the crux of the offer, and you'll see that at 5. And the relevant question in this case was whether the supply was otherwise than for a consideration, so the provision by Thorn of the phone to the customer, was that otherwise than for a consideration? If it was, then there were at the time deemed market value rules, so that's why the question was being looked at in that way. And if I could invite the court please just to read from 9 to 14 of the decision. bottom of page 317, 9 to 14.
We'll do that. Sorry, how far did you want us to go?
To the end of 14, please. And we would say that this is just another example of straightforward contractual interpretation, Charnock and Liverpool, with an explanation as to why that amounts to consideration for VAT purposes. And there's nothing special, exceptional, unusual about the analysis in Thorn. It's an example also of a unilateral contract, and we'll see when we get on to the next case of Empire Stores that that alone isn't enough to break the direct link between the supply and consideration. So if I can then move on to Empire Stores, please.
Are you going to come back to this on ground 2 or not? If not, can I ask you something about it in that context?
I wasn't going to rely on it for ground 2, but certainly, by all means, please ask your question.
Because we get to the end of 14, and I entirely understand that what's there being said is the consideration is given by the customer, irrespective of anything that Thorn may get from FODAC. But the tribunal then go on at 15 to consider what the position is in relation to the payments that Thorn gets from VODAC, which perhaps akin to ours are a fixed sum of money, although adjustable. And although I read this rather quickly, it looked to me as though the tribunal accepted that what Thorn got from VODAC was also sufficient consideration.
Yes.
And one gets that really at 18. For each supplier of each mobile phone, Thorn obtained a consideration consisting of 2 ingredients. So there was a consideration identified in paragraph 12 provided the customer, and there was the monetary consideration in the form of the adjusted connection bonus provided by VODAC. Yeah. So it seemed to me that this supported your round 2 assessment, but do tell me if I'm mistaken in that.
No,
you don't seem to be relying on it in that context.
Well, we were predominantly relying on it in relation to no monetary consideration. In relation to monetary consideration, I suppose the only point that I would want to make is it didn't arise in this way in Thorn, because the way that the VAT Tribunal dealt with the non-monetary part was essentially to say, well, because you've paid VAT on the monetary part, there's therefore no further value that we're going to attribute to the non-monetary part. Whether that attribution is wrong or right, because this predates Empire Stores, there can be potentially a question mark over. The only point that we wanted to make is that you can't have double counting consideration, and none of the tribunals below nor the Revenue have suggested that on the one hand it's non-monetary consideration amount cost, plus also monetary consideration amount 150, because that on any view analytically overall can't be right. So I hadn't necessarily intended to take you back to this for the monetary consideration point, because we get there, we say on first principles. But we also say that if you agree with our primary analysis, the search for consideration stops at that point, because you've identified that which the policyholder doesn't return. We're not now needing to look for some extra consideration that may pass via the insurer as well.
I follow your point that it can't be both in the context we're looking at it, but it could be both in the context where the only question was the supply for no consideration, in which case either would do.
And that's how I would say that, given the job before the tribunal may well have I appreciate the tribunal didn't say, well, it's one or the other, but the tribunal does in effect say, well, we find consideration here. Also, we could find consideration there. So I don't think that the tribunal is saying it's two lots of consideration, because that wasn't the case in front of it, and we would say that two lots is in effect double counting. So rationally it can't be two.
I understand. Thank you.
So then the next case to come on to is Empire Stores. And as I've trailed, this is important for two reasons. First of all, it shows that a unilateral contract can give rise to the relevant consideration for VAT. It also tells us the answer in relation to the monetary value of consideration in this case. So that's behind tab 17. And if I could ask you please just to read the head note first. And so you'll see that there are the two separate schemes, so two separate types of unilateral contract that could be entered into. The introduce yourself is the closest comparator we have to the policyholders. Someone that Empire Stores had no previous relationship with. They simply turn up, place their order, pay their money and say, we'd like a toaster. And they're given a toaster. The relevant point about the toaster, for example, is it's not a toaster from Empire Store's sales catalogue. It's simply a separate list of gifts. In inverted commas, of course, they're not provided gratuitously, we know, but gifts, signing up gifts, introduction gifts. And so the customer doesn't know the retail price because these are not items that Empire Stores offers for retail anyway. And so if I could ask you please just go to 14 to 17 of the Advocate General, which is page 329. And 14 through to 17, nothing is new. It's the same application of the previous case law in relation to direct link. There was an argument as to whether the payment for the items that the customer did order from the catalogue could be consideration for the gifts. Answer for the toaster, answer no. So what's the advantage and what's the consideration received by Empire Stores? And at 15, the Advocate General sets out that it's, in essence, the introductions that are crystallised by the concluded contracts. Therefore, there's consideration, 16. Is it consideration for that? And we see the Advocate General goes through the tests. And then at 17, the Advocate General concludes there is a direct link. The introduction and provision of the information is under both schemes a conditio sine qua non for the supply of the gifts. There is a direct link. And then, moreover, it cannot be said that the value of the gifts is unconnected with the economic value which the introduction has for Empire Stores. And if I could just ask you, please, just to look at the last sentence in 18. So in 18, the Advocate General is setting out the advantages that Empire Stores obtains. Last sentence, just by little e, is the Tribunal observes in its provisional decision the value of the introduction unquestionably has a subjective value for Empire Stores, since it was prepared to give for it an article for which it had paid the cost price. That's where the notion of cost comes in. Then if I could ask you, please, just to move on to the judgment. 4 and 5 summarise the facts. And then if I could ask your lordships, please, just to turn to page 335. And you'll see at 12 and 13, yet again, the court recites exactly the same case law. So I just emphasise that whether something's a bilateral contract or unilateral in the court's eyes makes no difference, is of no odds to it. And then if I could ask your lordship, please, to read from 16 through to 19. 16 through to 19 of the judgment. And 16 in particular, it is essentially the parallel of our case. It's the beginning and the end of the existence of there being a direct link. The link between the supply of the article without extra charge and the introduction of a potential customer must be regarded as direct, since if the service, i.e. if the introduction is not provided, no article is due from or supplied without extra charge by Empire Stores. So if the policyholder does not enter into the insurance contract, no device services are provided by ISL to it. And that is all that was required in the unilateral contract case for there to be a direct link in that. 17 to 19 set out how then we go about valuing the consideration. I'll obviously leave my learned friend to develop his argument on non-monetary consideration, and I'll deal with it fully in reply. But I would say this, one of the points he makes in his skeleton is, oh, Empire Stores was a case about goods. And I say, well, that's of no odds, because services still have a cost. Here we very much know what the cost of the devices are and the cost of the fitting services are. So there's no distinction at all to be drawn with whether what ISL supplies is goods or services when we are answering the question, did ISL receive consideration, and if so, what's its value? It's the cost of the services provided, the cost of the supply.
Yeah, it's a case of non-monetary services being given in return for the supply. And as I understand it, what you get out of paragraph 19 on capable of being expressed in monetary value is that there are two ways that one may be able to determine that. That's to say the subjective monetary value. It may be that you can see that it's what's been agreed between the parties, which would be naturally yours situation.
Exactly.
But in default of that, what matters is the recipient of the consideration services, if I can put in that.
Yes.
And if you can see the value that the recipient of the consideration services puts on it in monetary terms, then that's sufficient for it to amount to monetary value, irrespective of whether the receiver of the original supply and the provider of the consideration services is able to see what that value is or not.
Exactly. And so when your lordship asked in relation, or made the point in relation to naturally yours, well, both parties knew. I said yes, they did. I was pretty sure, but I didn't want to commit myself, that Empire Stores does actually deal with that expressly. So it's from the point of view of the person who's willing to hand over the goods or the services. What did it cost them in return for that which they're getting? And here, of course, there's no market value for introducer services in the relevant context. There's no other objective means, and the court tells us that objective is not the right standard anyway. It's what is it worth to the parties, and here in particular, the recipient of the services consideration to use that language, so ISL. Then moving on through the cases, I think I can just touch on this very briefly. The next case that I was going to show you is Commission in Finland. That is in the Authorities Bundle, tab 19. I'd just like to show you, I think, the paragraphs that I should have quoted in my skeleton, so you've at least read them. So, very briefly, the heart of this case was about whether or not public lawyers, public legal officers were carrying on economic activity. In order to carry on economic activity, you must be making supplies for consideration. So the supplies for consideration question was looked at. That's necessary but not sufficient for economic activity. The legal aid services were provided not for free, but they were provided for some fee in return, but the fee was primarily calculated by reference to what the client could afford as opposed to the hours spent or so on and so forth. And there was a sliding scale, and the crux of the decision is it was more like a contribution, a fee. What the court found was that nevertheless, notwithstanding the disjoint between the services actually provided, so the hours spent by the lawyers and the money actually handed over, there was still a direct link for consideration, there was still a quid pro quo, you've given something, but that was not enough for economic activity. We're not concerned at all with economic activity here. And so the paragraphs that I should have taken you to, 43 to 46 in the CJEU, which is PDF page 391. 43 to 46. And if I could ask your lordships just to read that briefly. And so, just pausing there before you read on, because I should explain the subsequent paragraphs and why they're not about consideration. But I just want to point out at 46, the comparator that the CJU is setting up here is for consideration versus free. And this is why we put a lot of emphasis on this is a contract between you, the policyholder, and us, Ingenie. If that contract wording is to be respected, and English law tells us it must be, it should be, then we here have something that was not done for free. What is the consideration? When you read on, and this is the mistake that I made when I drafted my skeleton, you do absolutely see the language of direct link appearing in 47 onwards. And this is the extract that I cited. And the point that I was going to make is, here there's no direct link because it wasn't parity, because of the discount. We obviously aren't in that position. I don't need to make that point because of a case called Wakefield that was decided by this court. Wakefield points out that when you look at the French version, it becomes clear that 47 onwards is actually talking about the separate, more expansive question of economic activity. And I provided Wakefield as an attachment to my email in the relevant paragraph. So this court has already decided that 47 onwards is not to do with consideration. We are simply concerned with up to 46. And even where there's an incredibly loose relationship between the amount paid and what was done, the relevant point was it wasn't for free. There was something that's consideration. And I mentioned the fact that 47 onwards is about economic activity. In Wakefield, the Court of Appeal goes through very carefully the French version of the decision in Finland, plus also a subsequent case. And there's quite a lot of patching in order to work out that that is actually the correct position, because superficially, it certainly looks like the court's talking about consideration, but actually it's not when you read it. And I should say my learned friend agreed. I'm very grateful he was actually the one that pointed out Wakefield to me, so that's not something that's in dispute between us. So that's Finland. One of the cases in my learned friend's authorities is a case called San Domenico. I'll let my learned friend discuss that if he wishes to. My reading of it is it doesn't contain any new principles at all. That was a case all about whether there was consideration for the secondment of one employee from one group company to another, when all that was being paid was cost, and the answer yes is yes, that was consideration. And if I may maybe just ask you briefly to go to page, so this is bundle tab 26, page 537, paragraphs 24 to 29. Essentially explain that it doesn't matter that the consideration received in return was simply equal to cost, or that there was no aim of receiving consideration from the arrangements. It was simply recharging between group companies. I don't think there's any particular relevance to this case, and if there is, I'll let my learned friend expand on it in his submissions. The last European case then that I mentioned in my skeleton, Gemeinde A. This is behind tab 27 of the authorities. And this is the SPA tax case. So a municipality charged what was called a SPA tax on certain residents and visitors to recoup its costs of improving its spa. Visiting the spa was free, whether or not the individual had to pay spa tax, because not everybody that visited the spa would have to pay spa tax. And certainly just because you paid spa tax, some people never went to the spa at all. Unsurprisingly, the conclusion was no direct and immediate link for reasons that are quite obvious now we've read the rest of the cases. The facts are CJAU 15 to 19. And then 31 to 40 is the judgment, is the reasoning I'd like to focus on, please. So 31 to 40. This was a case where the question posed was there an economic activity? The court said, well, given that for consideration is a necessary part of economic activity, we're just going to reformulate it and we're going to answer that question. And the court decided that it wasn't, that visiting the spa was not for consideration. The spa tax was not consideration for spa visits. At 33, the court sets out the familiar test. At 40 as well. And then at 36, it follows from the court's case law that there's a direct link where two services are mutually dependent on each other. That is to say that one is made only in condition that the other is also made and vice versa. That was the quote in my skeleton. I do not, in the context of this case, and also now that we've seen Empire Stores, think that the court can be interpreted as trying to make a point about bilateral contracts only. It was simply saying, so to compare to our case, if you enter into the policy, you will receive device services. We're bound to provide you with device services if you enter into it. We're not bound to provide you anything if you don't. That's the only mutuality that's being talked about here. And that has to be right, having seen Empire Stores. So those are the relevant European cases, and including Thorn within that. And we say that now that you've seen the case law, there's nothing scientific or onerous or complex about the concept of direct link incorporated into that being the notion of reciprocity. It's simply, have you done something in return? If so, you have for that which you have received. If so, you've provided consideration. And without wishing to rehash, but I just want to summarise where we say these cases get us to. It's been accepted that we have made a would-be taxable supply of device services. The only question is, did our policy, was that for consideration? The Upper Tribunal and First Tier both agree rightly that entering into a contract can be consideration, but they say for reasons that seem mainly to turn on the lack of express words on the page, that wasn't what happened here. They haven't rationalised how it can be so that we have a contract, so therefore there must have been something of value that the policyholders gave in return. They also haven't rationalised that position with, for example, Empire Stores. This is a unilateral contract, no different to that in Empire Stores. And so at the very heart of it, we've seen from the customer journey, the policyholders are given the policy wording in advance, and whilst there are no express words on the page, the only way to interpret what happens is, if you take out this policy, we will fulfil our promises under Section 1, you will have a binding contract. And that's the relevant reciprocity, that's the relevant direct link. There's nothing more complex than that for VAT. And in particular, what neither of the tribunals did below is offer any explanation as to why it is that what we say is consideration isn't for that, in circumstances where surely there has to be something provided in return of value when you analyse the contracts, which is step one. I've already made the point, and we'll see this when we look at the Upper Tribunal in particular, there's an awful lot of merging between what the contract provides and whether or not that's a direct link. But actually they're two separate exercises. Work out the rights and obligations first according to domestic law, the domestic law of contract, how you would construe the contract. Once you know what's going on, ask the direct link question. And really, once we have established that the relevant in return for is the entry of the contract on the domestic law, there's simply no room to come to any other answer in relation to direct link, because this is a straightforward case and there is no fact principle that suddenly changes that which we believe to be the case, having looked at the matter as a matter of rights and obligations under the contract. And we do say that you can test whether the Upper Tribunal and First Tier went wrong by asking the question, well, how do you square this? We've accepted that there's a contract, therefore something has been provided in return. Neither the Upper Tribunal nor the First Tier make any attempt to say what that is, if it isn't the non-monetary consideration of entering into the contract. And my learned friend may say, oh, but that wasn't the question they needed to decide. Well, it may not strictly be the question before them, but in order to test the cohesion of their analysis, it is something that they need to grapple with. Because it can't both be right that there is a contract, which there plainly is, but what you identify as consideration isn't consideration, isn't given in return in the relevant sense. Because if you can't identify something else that was given in return, that points strongly to our non-monetary consideration candidate as being correct. The last case I want to go through is South African Tourist Board. So this is the Upper Tribunal's decision. If I can just show you, Lordships, first where this was covered in the decision. Please can I ask you to go to the core bundle, tab 7, which is the Upper Tribunal's decision, page 101, which is paragraph 85, please. And you'll see that the Upper Tribunal has itself sought to emphasise two sentences or two phrases in this paragraph in South African Tourist Boards. The first one is the phrase falls far short of demonstrating the degree and nature of reciprocity required. And our criticism of that is when you understand exactly what South African Tourist Board is deciding, why it is that we're a different case to that. If the Upper Tribunal meant by emboldening that this is some sort of high hurdle test, I've just shown you all the case law, which makes it very clear it's not a high hurdle. In particular, if I may say Finland, there didn't need to be any sort of one-to-one parity. You've given something that's good enough for consideration. And then at the end, the linkage is not one of mutual exchange of supply and consideration of that supply. Well, I take no issue with that, and I've demonstrated to the court already why we say it is a mutual exchange. So South African Tourist Board is in the authorities, tab 20. And if I can just please paraphrase what's going on here, there are two separate things that are going on in this case. One of them is not dissimilar at all to Appellant Development Council. There was a funding agreement from, I think it was the South African government, yes, it was the South African government, put in place as a result of which South African Tourist Board would perform certain services for the benefit of the tourism industry loosely. There was a second contract, which was more specific, which the Upper Tribunal found did actually create a direct link between consideration, the payments received in services by South African Tourist Board. And that's referred to as the TBSCA, and we'll have a look at that in due course. If I could ask you please just to read the head note briefly. And so just to emphasise, and we'll see this in the decision in due course, between F and G in terms of the holding, the summary is, although the government receives something of value to it, that value was received as an incidental outcome of the ability of the Tourism Board to perform its statutory duties by virtue of the funding it had received. That's an indication that this actually is a real case of you haven't made supplies for consideration because you haven't actually given a supply to your payer, which isn't our case because we know that we have made a supply to the person that's paying. And what we'll see is that the quote that the Upper Tribunal relies on is actually made in that context. So why it is necessary in order to look at all the facts and so on in order to work out whether there has actually been a supply made in return for the money. It's not a quote that's specifically about direct link in our context. So if I could ask you please just to go through the judgment, you'll see the facts are set out at 7 and 8, the creation of the South African Tourist Board. Part of the relevant background here is that certain duties were imposed on the Tourist Board by statute. Now, I suppose you might say that the comparator in our case is the insurance contract and imposes certain requirements on ISL, but that, as we'll see in due course, does not mean that it was not possible for the Tourism Board to be making supplies in return for consideration. 11 and 12 set out the funding arrangements. And then 17 through to 20 refers to the performance agreement, which, as we'll see in due course, the Upper Tribunal simply described as being something that you'd expect to be agreed between a funder, but not sufficient to actually elicit from it transactions amounting to supply. So that's 17 through to 20. You'll then see at 23 through to 25 the separate levy, the TBCSA levy, which in due course we'll see the tribunal was satisfied was actually consideration in return for an identifiable supply of services. Then the analysis supplies for a consideration at 35 onwards. You'll see there's a discussion of the case law, starting off with the Dutch potato case, and looking at the summary at 38 of that case. Appellant paired development is then discussed next. C especially in that regard, 42 and 43. So the tribunal here is recognising this as being money was paid, albeit for no defined direct benefit in return. Tolsma 46 and 47 are the criteria that we're familiar with. And 49 is relevant. At 49, the Upper Tribunal here rejected the revenue submission that there couldn't be a supply for consideration because the South African Tourist Board was under a statutory duty anyway to perform its functions. So the fact that the South African Tourist Board has to be carrying on these things because of statute does not mean it can't, in the process of doing these things, be making supplies for consideration. At 51, the tribunal started with the contract and then asked itself, does it reflect economic reality? At 52, the tribunal discusses the performance agreement. And you can see between F and G that all it does is that it sets out objectives, targets and deliverables and records the funding that the department is committed in principle to provide. And then if I could ask you please to read 55 through to 60. And so the important point to take away is the crux of the decision here is that the Tourist Board was not providing services to the South African government in return for its funding. That's not our case. So where at 56, the tribunal starts off by saying, in our judgment on its own, the performance agreement falls far short of demonstrating the degree and nature of reciprocity required to constitute the payments made as consideration for supplies. That is because, on the finding, not, oh, we can't see any money being paid, we know there's money being paid, but because what the Tourist Board was doing did not amount to supplies. And that's not our case, because it's already been agreed in our case that ISL is making supplies of the device services. We can see that from the end of 56, just above G, there is a link between the funding and the performance of its functions in accordance with the agreed business plan and objective, but that is consistent with an arrangement of negotiated funding. There is nothing in the agreement to deflect away from that analysis towards a transaction of supply. So all it is a funding agreement with objectives and targets. It is not a transaction of supply. And then the linkage is not one of mutual exchange of supply and consideration for that supply, but the reason is there is no supply. There are no services being provided by the tourist board in return for the money. That's not our case. You see this again from 58, the bottom of 58. The fact that the funding is determined by an iterative process involving negotiation to achieve a consensus does not result in there being the necessary reciprocity or mutuality to convert a funding arrangement as contemplated into a transaction of the supply of services for consideration. Um, 59, the whole tenor of the Tourism Act and the performance agreement is one of the funding of the board's activities. We regard that as a different legal relationship from the one contemplated by the reference to supply of services for consideration in the VAT legislation. The performance agreement operates not to record the supply of services, but to crystallise the funding at the level to support the programme of activities. Then there's a difference between agreeing the value of something for the purpose of providing the appropriate level of funding to enable it to be done, and agreeing the value of a service for the purpose of paying for that service. The mere act of agreeing a value is not decisive of the required mutuality. In this case, the negotiation agreement as to value was a function of the oversight for the arrangements by the funder and did not provide a monetary exchange for a service provided. So read properly, of course the overarching question is there a supply for consideration? But the decision is there was not actually a supply of services. So obviously there's no direct link between a supply and consideration because the first part is missing, there's no supply. And then 60, the fact that the government received benefit is relevant but again not decisive. That value was received as an incidental outcome. And this is why cases such as Appellant Development Council are relevant, because the reasoning in that case is the same as the reasoning in South African Tourist Board. Nothing identifiable being done by the would-be supplier. That is important because of the emphasis that the Upper Tribunal sought to take from this notion that, well, there are lots of things that feed into whether or not there's reciprocity, and this is a case that falls far short. The falling far short is in relation to a finding that there's no supply being made at all. And that's absolutely not our case. It's not because once you've established a supply, there's some additional higher hurdle in order to work out whether it's for consideration or not. And again, you see the point that this is really a case about no supply at the bottom of 64. The arrangement was one of funding with the appropriate provision to ensure performance and not a transaction of the supply of services. Now, the reason that I have laboured this so much is because the Upper Tribunal then goes on to discuss two cases that the parties relied on in the VAT Tribunal. The first case is the Netherlands Board of Tourism, and that is 66 through to 69. And the second case is a case called Tour España. That's discussed 70 through to 75. If I could ask you please just to read 66 through to 69. Actually, I'm sorry, I actually don't need to take up your time with that. 66 through to 69 is the discussion of the first case, but the relevant point is actually made at 68 and 69. The Upper Tribunal, having recited in the earlier paragraphs the various relevant facts, at 68, the Upper Tribunal says, well, we can obviously see why the Upper Tribunal wanted to place reliance on this winning case. But NBT was a case decided on its own particular facts, and the significant feature of NBT is the finding by the tribunal that some of NBT's supplies were made to the Dutch government. So that's important because NBT is a case where the relevant board had been found to be making supplies before considering the question of whether those supplies were taxable or not. And this, having decided that NBT was making such supplies, it is not difficult to understand the conclusion of the tribunal of the question of direct link and consideration. And if I was going to embolden any sentence in this decision, it would be that sentence, because that is where we are. We are not in the para 56 world of rooting around trying to see whether or not ISL has made supplies, already decided that it is. The world that we are in is the far easier rationale, once you've established supplies, of finding a direct link for what has been done in return. And then the difference in Terra-Spania, you'll see Terra-Spania is discussed 70 through to 75. Terra-Spania is a case where the tribunal reached the opposite conclusion, 74 and 75, basically because, as you can see from 75, the tribunal concluded that there were no supplies by Terra-Spania, no consideration was received as a quid pro quo, and there was no direct link. So, in and of itself, South African Tourist Board doesn't establish anything new. The reason for showing you this, though, is it absolutely highlights a potentially difficult exercise in some of these government funding cases as to working out whether or not the would-be supplier is actually making supplies, but it absolutely does not set a high hurdle for then, if you find that supplies are being made, the test for a direct link to consideration. That's not what these sorts of cases are about, and South African Tourist Board actually sets out the difference very nicely, in particular in its discussion between the Netherlands case and the Spanish case. And as I say, actually, if I was going to emphasise and bolden any sentence in this, it would be the last sentence of paragraph 68. Having decided that NBT was making such supplies, not difficult to understand the conclusion of the question on the questions of the tribunal on the questions of direct link and consideration. Those are not hard tests when you are in a situation as we are in. So that takes me to the end of the discussion of the authorities. What I now wanted to do was summarise what we say are the errors in the Upper Tribunal decision. And just for your note, we've gone through in some detail in our skeleton argument the paragraphs 40 through to 66, paragraph by paragraph, where we say the Upper Tribunal went wrong, and I adopt the points that we made therein. I just, though, want to go through some of the highlights, if I may do that briefly, please. So it's the Upper Tribunal decision, core bundle 7, tab 7, starting off with paragraph 81, please, which is on page 101. So, 81 is the Upper Tribunal's conclusion, which we disagree with for the reasons I've just given you. 82 to 83 is simply quoting the cases, no problem with that. On 84, at 84, you'll see that the Tribunal has decided to pluck out a couple of phrases from the Advocate General's opinion in Tolsma that in all the recitation and repetition of the direct and immediate link test by the court we have never seen again. This notion of stipulated exchange, stipulation of price, an element of contractual exchange. If what the tribunal meant by that was that something had to be in writing, that's obviously wrong for the reasons I've spent the morning explaining. If what was meant by that was, well, it's a bilateral contract, sorry, you have a unilateral contract, we've seen from Empire Stores that that's not a bar. So it's unclear exactly why these sentences were chosen, other than they help support the thesis that we somehow have a problem because we didn't have a sentence setting out if you enter into the insurance contract, will provide the device services, which we say, as a matter of contractual interpretation, is there implicitly. We've already looked at 85, and I've already discussed why the Tribunal's approach to South African Tourist Board and its preferential reading of those two sentences is wrong and out of context. At 86, just to be clear, we do accept that South African Tourist Board sets out principles. The problem is that what the Upper Tribunal in our case took from that case is just wrong and a misapplication. Now, at 87, we don't disagree with the proposition that there'll be a range of factors to consider in every case. But what we do say is, whereas in our case the Tribunal has already decided that we are making a supply of the services, the factors for consideration reduce dramatically. And actually, there's not really a range of factors to take into account on direct link once it has been established that we are making a supply of services. It's a simple exercise of asking what was done in return on the contracts as construed as a matter of domestic law.
And the question is ultimately, presumably, one of law.
Exactly, and we made...
Whenever people begin talking about multifactorial evaluations, one fears one is straying into the territory of the tribunal below is entitled to reach such and such a conclusion, but we're not in that sort of zone at all, are we?
And I think I cited it was the Bahamas case, which is referred to in Craft Carnival, and I think I put in either our skeleton or our application. The construction of a contract is a question of law. There's a separate exercise, once you've construed the contract, that being a question of law, which is, does economic reality change anything? We're not making any separate argument about economic reality. Here we say the economic reality follows the construction of the contract. Once you understand that construction of the contract has built into it implied terms, commercial common sense, and so on. And your Lordship's question, actually, one of the other criticisms, built into the tenor of the discussion, although the Upper Tribunal never says anywhere explicitly this is a multifactorial exercise, the way that the first tier discussion is, the first tier decision is discussed, the first tier on all the facts was entitled to come to this conclusion, is entirely the wrong exercise, when what you have to start off with is construe the contract question of law. It's not multifactorial. And that whole tenor of the discussion is wrong. So 86 and 87, as I said, and actually as I've shown you by going through the cases, we do not disagree with anything. Our case relies on applying all the principles we've seen in the cases. The Upper Tribunal went wrong in its understanding, and its very selective choice of the little snippets that the Advocate General, in a case from 1988, which has never seen light of day since in any of the judgments, talks about stipulation. And this has become something far more than it's supposed to be, being, well, you didn't have writing, therefore this is a problem for you, looked at in the round, but that isn't the right exercise at all. So as I was saying about 87, we don't disagree with the sort of overall proposition that there are a range of factors, but the exercise here is a very different one. Once the contracts have been construed, we don't think there are any further relevant factors that are a block for us establishing a direct link. This is a case where the English law notion of consideration travels exactly in line with the VAT notion of consideration, something in return for. That's it. There's nothing wrong per se with 88 and 89. So yes, the question, is there a legal relationship, is different to the question of whether or not there's consideration pursuant to that relationship. That's 88. And 88, the second sentence I've already shown you, the First Tier and the Upper Tribunal both accept that entering into a contract could be consideration. 89 simply poses the question, was there a direct link? I suppose the only quibble that I would have was 89 is, put another way, was there a sufficiently direct link? Well, in the cases that we've shown you, sufficiency just isn't an element. Sufficiency may be a question if you're looking at whether or not services were supplied, what was it that was being done by the would-be supplier. But it's not really a question of sufficiency, it simply was something done in return, yes or no. It's binary, it's law, it's not evaluative, there's not a sliding scale. It's not a question of degree, which one might say is what is meant by sufficiency.
Put another way, it's reciprocity which defines whether the direct link is or isn't a sufficient direct link.
Yes, yes, yes. But it's binary, it's not really a question of degree on the facts in a case such as this. Well, I wouldn't even say it's binary, I would say there's only one right answer. But it's not a question of degree, is my main point in approaching this. Nothing wrong with Upper Tribunal 90. We do make our case out on section 1 of the policy booklet. Now, 91 is the core paragraph, and this, we say, contains material errors of law in a de Gauss sense of materiality, so the Court of Appeal can intervene, materiality simply being the construction of the contract point. So just looking, if I may, quite carefully at... In fact, if I could invite the court, please, just to reread 91 before I discuss it. So just to summarise, first of all, the Upper Tribunal doesn't properly separate the prior contractual interpretation exercise and identifying the parties' rights and obligations as a matter of English law before turning to the separate VAT question. It deals with it all as one sort of a whole, trying to establish rights and obligations through some sort of VAT lens, which just isn't right, which is why we have the reference again to Tolsma and whether or not things were stipulated. That's not the contractual exercise. Secondly, insofar as the Upper Tribunal thinks there's some sort of specific principle requiring rights and obligations or consideration to be in writing, it's wrong, and I've shown plenty of cases, including, well, plenty of cases about that. That's simply a pure domestic law question. Interpret the contract. We don't need everything to be in an express term. That's fundamentally wrong. And we would say here the Upper Tribunal is making the same type of mistake as that made by the First Tier in Craft Carnival. Well, you haven't shown me a term that says you are obliged to provide a fare, therefore you're not obliged to provide a fare. In contrast, you haven't pointed to words that say if you enter into the insurance contract, we promise to do these things in return. But that's not a bar to the contractual interpretation. And thirdly, your Lordship's point, the Upper Tribunal also here appears to be treating the contractual interpretation exercise as one of factual evaluation, which is wrong. It's a pure question of law. Now, 92 onwards...
Just before you leave 91.
Yes, of course.
One of the ways I read it, I may have been wrong, especially the third line onward, FTT stated the difficulty with that case was the 2015 policy booklet doesn't contain any term under which the policyholder agreed to do anything or allowed anything to be done in return for the provision of the first device. And that's essentially the reasoning they uphold. And that seems to be couched in the language of a bilateral contract where what your one is looking for is a promise of performance by, in this case, the policyholder, as the quid pro quo for ISL's promise to provide the services. Whereas if we are in the realm of a unilateral contract, that's not what one's looking for.
Exactly.
One's looking for whether doing something
Is consideration.
is the consideration.
Exactly.
And they had identified earlier that entering into the contract, insurance contract, could be consideration, but perhaps lost sight of that when adopting the reasoning as to looking at whether there was any promise on the part of the policyholder.
And another way we would put the criticism here is, excuse me, I'm sorry. The Upper Tribunal has failed, having started from the premise that entering into the contract could be, why isn't it in our case? And if the answer is there's no exchange in writing of promises, bilateral contracts, well, I point to Empire Stores, which makes it very clear there doesn't have to be.
You know, if the consideration is doing something, there's no point focusing on what someone has said in the contract.
Exactly. They've simply done it. And Empire Stores couldn't be a clearer example of the CJU making it clear that that is sufficient consideration. What's more, which has a value. This is why I think we struggle with really getting to grips with what exactly the First Tier and the Upper Tribunal find objectionable. And we come back to the fact that they seem to think that you need to have promises on a piece of paper that everyone has signed up to, and then everyone goes away and perform, a bilateral contract. But the cases are clear that's not it. Now, 92. There is a discussion here about the First Tier considering two other arguments raised by ISL. I make a couple of points. I've already set this out, and I'm just looking at the time. I've already addressed this in writing in our skeleton argument, so I just ask that perhaps the court may read it overnight. I don't intend to go through at length 92 onwards. We say we're right about the submissions we made, but on any view, the court's essential reading, if you like, is all encompassed within 91. If 91 is wrong, there's a material error of law. Whether or not the First Tier was right in how it dealt with subsidiary arguments we made is neither here nor there. Maybe we're right, maybe wrong, doesn't matter, 91 is really where it's at. But for the reasons I've set out in writing already, 92 onwards is wrong for the reasons in our skeleton argument. And just to summarise, it addresses the first subsidiary argument at 93 to 98. But again, this is infected with the same sort of error. The Upper Tribunal fails to separate the contractual exercise from the VAT exercise. The Upper Tribunal places weight again on the absence of a written term. The Upper Tribunal also introduces asking the question in terms of price for installation and what was the policyholder paying. But I've shown you all the case law, and the case law is not discussing price and paying. The case law is couched in terms of reciprocity, direct link, in return for quid pro quo bargain. And again, at 98, so perhaps this is a clear example of the error, the Upper Tribunal uses the language of contractual exchange, perhaps again suggesting that it's focused on bilateral contracts and thinks somehow that a unilateral contract can't have consideration for that, which is plainly wrong. Now, we made at 99 the argument that it would be objectively important and correct as a matter of contractual interpretation for the policyholder to have enforceable rights in relation to the device against ISL. I want to be clear, whether or not that's right or wrong does not actually matter in terms of the overall analysis. And I don't necessarily want to get drawn back into debate as to whether or not, in fact, there are rights against the insurer in relation to the device. But our point that's set out in writing is, objectively speaking, Section 1 is a contract, and that gives enforceable rights of the policyholder to the policyholder against ISL in relation to the device. At Upper Tribunal 100, again, the Upper Tribunal wrongly relies on this notion of the absence of clear wording. And at 101, the Upper Tribunal focuses on the wrong thing when it says, the first tier identified one aspect of the transaction as a whole as the primary rationale for a policyholder, which was to obtain insurance and do what is necessary to do so. That doesn't answer the question as to whether there's a direct link between an accepted supply and something done in return. It's simply not a relevant question to ask. And there's a reference to impermissible double counting in 101. But if I may say, that's a question that seems to go to really a contractual interpretation. And the case of Charnock and Liverpool tells us that you can have one contract between, in that case, the garage, who's contracted to repair a car, but also has a contract for consideration, contracted to the insurer to repair the car, but who also has a contract for consideration from the car owner in relation to the car owner. That's all I wanted to say in relation to non-monetary consideration, unless there are any questions from the court. Thank you.
Thank you.
I want then to move briefly on to monetary consideration. And I actually, it's set out in my skeleton argument in paragraphs 67 to 74. If I could just actually make my submissions by reference to those paragraphs, please, because none of these points have ever actually been addressed by either tribunal, who have both ignored our actual case, which is third-party consideration, notwithstanding that third-party consideration was clearly expressed in both of our skeletons, in our skeleton before the upper and the first tier. So our Court of Appeal skeleton argument is core bundle tab 4, and we set this out at paragraphs 67 through to 74. And just to assume a relevant correction to the diagram that we had discussed previously. None of the Upper Tribunal's reasoning at 103 to 120 deals with the third-party consideration point. In short, you can see, and I've already showed you, Lordships, paragraph 68 we've quoted again. At paragraph 70, we've quoted again Article 73. Article 73 tells us that consideration can be provided by a third party if authority were required, and I've set out here the relevant quote from 47 Park Street. And the way we put our argument on third-party consideration is this. Once it's been established there's a legal relationship between the policyholder and ISL, pursuant to which ISL is making device-related supplies, which the Upper Tribunal has agreed with, that's not been challenged, then in the absence of non-monetary consideration, the monetary consideration is that being paid, and the loop would be, from the policyholder to ARL, and then the device amount plus commission is split off and paid to ISL.
But this isn't an argument that the policyholder is providing that consideration.
No, the third party point is this is money that is coming from the insurer. The reason it's coming from the insurer is the policyholder pays to the insurer premium. That premium includes the premium plus also the device amount, as we've seen in terms of the money flows. For every device that's installed, the insurer pays to ISL £150 or £165, doesn't matter, depending on what contract you're relying on. That is the third party consideration, and the relevant direct link, we say, is obvious. For all the reasons I've discussed earlier, there's never a scenario in which that 150 is paid where ISL hasn't provided the device services. Every time ISL provides the device services, it gets the 150. Even if, for example, as we've seen from the contracts, the policyholder cancels the policy, that 150 is not refunded. So we say that's the beginning and the end of the direct link, third-party consideration. In relation to the change vehicle event, we again see from the document means every time ISL provides the first new box, replacement box in a new car, the second, the third, there's a tariff of charges. That is money that it will get from the insurer. The insurer collects it from the policyholder by way of increasing the premium. So those aren't free to anyone. And that's the beginning and the end of our third-party consideration argument, which neither of the tribunals below addressed at all. I just don't know why. They preferred to answer the separate question, the different question, of is this money being provided from the policyholder? But that's exactly not what third-party consideration is.
It was certainly part of your argument below.
It was, but
the monetary consideration was consideration given by the policyholder, albeit via or at least that's how I read what was.
That's probably how it's been summarised, but I'm pretty sure that I might have copied and pasted a large part of my skeleton from the Upper Tribunal skeleton because the third-party consideration piece just wasn't addressed. I
accepted it wasn't addressed, and I accept that it was at least part of your argument. But that which was addressed by the First Tier Tribunal and the Upper Tribunal was, I think, also part of your argument on this aspect of the case.
I don't think it matters. I will need to double check my speaking notes because I'm not sure before the Upper Tribunal it was, because I think before the Upper Tribunal I really focused on the third party element. But I will check. I don't want to say that as a confirmed position without having checked. But on any view, the third party argument was there and wasn't dealt with. And certainly before this court, this is all we're relying on. Yes. The consideration was that which was handed over by the insurer.
Can I ask you a question on that? The third party consideration on this view has to be in return for the services supplied by ISL to the policyholder.
Yes.
Which is the installation.
Yes.
But I think you showed us in the terms of business as between ISL and Kavir, ISL contracted with Kavir that it would install the device. Why is that not the insurer paying for the service that ISL has contracted to provide to Kavir?
So the simple answer is in a case called Tesco Free Time. These cases were overcomplicated because they were looking at a different part of the answer. They were looking at, depending on who pays, is it permissible to recover input tax, which is a slightly different question. But Tesco is in the authorities bundle at authorities tab 25. And just to give a high-level summary, this is all about Tesco club card vouchers. I buy beans from Tesco, I get some club card points, I convert these into club card vouchers. The crux of the case was what happens when I come to redeem the vouchers. And Tesco argued and was right that when a customer came to redeem the voucher, say about voucher for a pizza at Pizza Express. Pizza Express makes a supply of a pizza to the customer. Question, was Pizza Express also making a supply of fulfilment services to Tesco? Answer, yes, but the only paragraph that I wish to show you, which I don't think as a statement of principle is being challenged, is at 44. So Tesco, tab 25, paragraph 44. It is Upper Tribunal, but I don't think any of this should be controversial. So we note first that the mere fact that the substantive obligation imposed on deal partners, so this is Pizza Express, undoubtedly involved the supply of services to club card members, so this is the provision of pizza, does not preclude the finding that it also amounted to a supply of services to Free Time. It is clearly established that a single event can constitute two different supplies to two different recipients. So what does that mean for this case? it is not a bar on our supply analysis, the fact that as between ISL and the insurers, ISL owes the insurers certain obligations in relation to the device. That does not prevent, and indeed we have findings that does not prevent ISL making device service supplies to policyholders, and then the only question is, was there consideration? And we would say that it's an extension of this case.
Well, so far so good. I quite see that particular activities might be forming supply obligations to two different people. So when you install the device, you're fulfilling the obligations in Part 1 of the policy to the policyholders, and you're fulfilling your obligations to the insurer under 4.1 or whatever it is of the COVIR agreement. I quite see that those are two separate supplies. But if what one has to decide is what is the consideration that, or what supply is the money that is being paid to you by the insurer for, I mean, naturally, although I see one can have third-party consideration in the abstract, normally money that one party pays to another is prima facie to be interpreted as money which is being paid in return for an obligation which is owed to the paying party. That's what one would expect it to be. And if we have in our case an obligation on ISL owed to the insurer to provide the device, and an agreement between ISL and the insurer that the insurer will pay £150 for that, one's natural instinct is to say that isn't third-party consideration for the supply for the obligation owed to the policyholder. It's simply second-party, i.e. party consideration for the obligation that's owed by the other party to the contract.
So all I would say is reducing the question to direct link, which would be the matter for VAT. For every device that's installed, £150 is passed over. That's come from the policyholder, but that ends up being paid by the insurer.
It's not direct link. Sorry, it's not direct link. It's whether it's being paid in return for that obligation at all. It's whether it's consideration for the Part 1 booklet promise. Not whether there's a link between the two, but whether when the insurer pays 150 quid, it's paying it in return for that promise.
If I can perhaps make, well, so I suppose we would say that when you get to the VAT question, there is the direct link for the reasons I've previously explained. What I suppose we would say is we would trace that through the obligation on the policyholder to make the payment in the first place, because the policyholder either pays or doesn't pay an additional 150 depending on whether it needs a device or not. What I would really want to say though is this: if the court finds that there is no monetary consideration, in order to respect the fact that there is a contract, this reinforces our argument that there's non-monetary consideration. And it won't have escaped the court that we have put the grounds in the way that we've put them. That's the argument we've made all along. Non-monetary consideration is our primary argument for all the reasons we've given. If the court decides that there's no money, third party, second party or otherwise, we know there's a contract, that must reinforce our first argument. And we've never tried to suggest monetary consideration is our first argument, it's been our fallback. But actually, the absence of monetary consideration reinforces our primary ground.
Because as you've fairly accepted, it can't be both.
Exactly. Well,
the consideration for the promise by ISL to the policyholder can't be both the non-monetary consideration of entering into the policy and the third-party consideration of payment by the insurer.
I suppose that the way that we would put it, whereas actually what I would say is the absence of monetary consideration reinforces our primary argument. I suppose what I would say is if we get on to our secondary argument, because you've rejected the non-monetary consideration argument, we know there's a contract, there has to be consideration. That's the monetary consideration that we would say somehow must therefore link. But again, we prefer our primary argument for the very reason that it's not both.
But if one stands back and asks the economic reality, you are getting £150 for each time you install and that's what you actually receive each time you install a box.
So taking it in stages, we would say that the correct approach is non-monetary consideration as between the policyholder and ISL.
Yes.
The 150, and again, this is, I suppose, this is, if we're wrong about monetary consideration, the reason 150 is being paid is because that is in return for, that's part of the commission that we are being paid by the insurer in return for the exempt supplies under the insurance contract. So assuming we're wrong about monetary consideration, that is how we say properly construed the arrangements work.
Well, I was just, are you going to address this on your Annex 1 and how you quantify how you value the non-monetary consideration?
So Annex 1 was Empire Stores and that part of my case. So I think I have addressed the court on that when I went through Empire Stores.
But one might think that one answer to that is to say this is a case of non-monetary consideration, namely the consideration is the entry into the insurance policy. Mm. But the value of that to you is the £150 you get out of the premium, rather than the Empire Stores analysis, what you actually receive for installing the box is the £150, which is the value to you of the policyholder entering into the policy.
So that the £150 would, on our analysis, is what the consideration would be if we're right on monetary consideration.
Yes.
I can see that
I'm suggesting it might be the right way of valuing the non-monetary consideration, because that's what the entry into the policy actually produces for you.
I'd make 2 points. I think my learned friend has already accepted that if we're right that you can value it, then Empire Stores shows us the way and it's the cost. So this wasn't an argument that I was expecting to have to deal with, and I don't have submissions prepared because it was common ground between the parties.
Well, that may be a complete answer.
But the answer may also be that if the consideration is entering into the insurance contract, full stop, by the policyholder, then of course that produces quite a lot of different benefits for ISL. It doesn't only produce the benefit of getting the device amount, it produces whatever profit it may be making out of the insurance arrangements and so on. And that's why you don't, for those purposes, look at just the device amount element that it gets back from the insurer, but you have to look at what it is prepared to pay for the benefits, i.e. the Empire Stores cost, because you can't just go directly into the device amount element which comes back.
So that is where we would say that we are starting to stray into apple and pear type issues. The only supply that we are valuing is the value of the device services that we have provided to the policyholder. The reason we get more money every time a policyholder enters into a contract is not purely because of the device, but it's because of other matters that are not the subject of any supply ISL makes to the policyholder, because that's the insurance contract. Put it another way, that there's no, in circumstances where we have ISL provides the device and the installation, there's a separate contract between the insurer and the policyholder for the insurance. Once that has been franked, there's no room, because that would then be double counting, to start attributing some of that consideration to a completely separate supply that has nothing to do with making any insurance services to the policyholder by ISL. That would be double counting if we're saying, well, we're going to take some of the consideration here, and we're actually going to add it on here. in relation to far more than you, ISL, have ever provided to the policyholder. Yes, of course, there's a larger background, but the supply, and there does come a point where VAT asks questions about the value of supplies, and the supply is the thing that is identified and demarcated by the contract. The supply that's been identified is ISL provides to policyholders the device services, no more, no less. That's a taxable supply for the reasons that the Upper Tribunal have identified, not least because ISL in no way is acting and being remunerated, being compensated to act as an insurance intermediary of the policyholder. That's a completely separate supply as between ISL and the insurer. And in relation to those services, ISL receives its consideration. Now, the answer may be, well, that means that whatever it is as between ISL and the policyholder can't be monetary consideration for the separate supply. And I accept that that may be the answer, but we then say, well, that's why, as between the insurer and the policyholder, we're confined to the non-monetary supply. And the consideration, what is it that ISL is prepared to give to the policyholder is the cost of the device and the fitting. That's where you get your answer from. Because ISL is not selling the device and the fitting services on the open market for some other money. It's what is it prepared to spend in relation to that contract, the device and the fitting. ISL will have all sorts of other expenditure that it's prepared to spend in relation to its contract with the insurer, but that isn't of relevance for us in relation to this question. And as I say, the revenue has already accepted that if we can show there's a direct link and they're wrong in relation to their overarching exempt supply argument, then Empire Stores is the correct way. And we're right in relation to monetary value, then Empire Stores is the correct analysis.
Okay, thank you.
All I wanted to say really in relation to, so that the fifth and final part of our presentation is dealing with the revenue's first respondent's notice point. Their first respondent's notice point is that, notwithstanding the Upper Tribunal's findings, ISL is somehow making exempt insurance intermediation services to policyholders. And all we have to say until I hear my learned friend's development of his argument is that the Upper Tribunal was right for the reasons they gave at 44 to 50 of their decision. So that's core bundle 44 to 50. And the short answer is any supplies of insurance intermediation we've seen from the contracts ISL is providing to the underwriters and the underwriters only. It is not contracted to provide any introducer services or anything of the sort to policyholders, and the tribunal rightly identified that. And there's no way without any other service of somehow suggesting that because big picture this is all in the broad context of insurance, this should somehow inflict on the device services some exempt nature, because ISL is simply acting as a supplier of technology services as between it and the policyholder. That's it.
Put another way, if you've got this far, it's because the consideration on which we put a monetary value is solely the quid pro quo for the services that you provide under Part 1 of the policy booklet to the policyholder. Yes. And if those are the services we're concerned with, none of those are the insurance intermediary services.
Exactly.
Which you're providing in the course of the insurance.
Exactly.
Is that another way of putting it?
Yes, and only to the insurer. And indeed, as is clear from that contract, it would be in conflict if ISL was somehow acting as an insurance intermediary as well of the policyholder. That there's just no provision for that to be its activities. So, unless I can assist the court further, those are our submissions.
Thank you. Right, Mr. Mantle will rise there. We'll start again at 10:30 tomorrow morning.
Very good, man.